SJC-12466, Commonwealth v. Eric A. Richards.
Mr. Bender, good morning.
Good morning, Your Honors. Robert Bender for Middlesex County for the Commonwealth. May it please the Court, we're here today to return and examine a specific section of the operating under the influence statute, section 90, chapter 90, section 24(1). And this is part F1 specifically, which indicates that where someone has had their license suspended for refusing to take the breathalyzer, as this defendant has, no license or right to operate shall be restored under any circumstances, and no restricted or hardship permit shall be issued during the suspension period imposed by that provision. Provided, however, that the defendant may immediately, on the entry of a not guilty finding or dismissal of all the charges as occurred here, may immediately apply for and be immediately granted a hearing before the court which took the final action on the charges for the purpose of requesting the restoration of the license that had been suspended for the refusal.
Mr. Bennett, can I ask you, if someone has their license suspended in this fashion, after the dust settles and suppose they lose in front of the judge immediately, do they have a right to go to the registry and seek a hardship?
No.
They have right to go to the Superior Court, though, right? If the district court judge doesn't return the license, there's a right to cert to the Superior Court.
If we're talking about after the trial.
Right. Can you if we could just separate out and finish my question. So, someone has their license suspended. They go to the trial judge. The trial judge says no, like this trial judge did.
Yes.
2 years goes by. Your argument is there's no more immediacy, and then they exhaust or they don't file in Superior Court, right? 2 years goes by. Can they go to the register and say, I want a hardship like someone else can?
I haven't found any authorization for that in the statute.
Okay.
Except for the statement here that says that no license can be restored during the period of the suspension.
So you view this essentially as the equivalent of life without parole. There's no executive capacity to effectively parole the person for this violation.
Well, other than some sort of clemency from the government, I imagine, this is in case even in serious.
How can you actually, can you give a clemency? Because he was found not guilty. Sort of a,
no, but he has suffered a consequence of this whole proceeding, and I haven't examined it, but I would imagine that this is something that also can be forgiven. If we can forgive a murder, we can forgive a refusal.
Talk a little louder. I'm having.
I'm sorry. I have trouble hearing, and so my hearing aids are up a little loud, and I couldn't tell how loud I was speaking.
Well, I suppose if the governor granted clemency for one of the prior OUIs, then the hardship, by definition, wouldn't be a lifetime.
If the governor could do something, then that would be the case. But the thing is this: unlike the suspensions for being convicted of driving under, where you can, after a period of time, according to the statutes, apply for a hardship license or what they also call a restricted license a little bit earlier to go to a job or to go to school, there is this specific language in F1 that the legislature has adopted, that no license will be returned under those types of situations. You must serve the entire period of the suspension. And with someone with the record that this defendant has of having 3 prior convictions before the night he was asked to take the breathalyzer, he's facing for refusing a lifetime suspension.
So, Mr. Bender, the statute obviously says immediately upon entry of not guilty finding, apply for and immediately grant a hearing. Despite the statute saying that, Judge Kilmartin, some amount of time later, had a hearing. I can't remember, maybe a year later. Then another judge had another hearing, and then the judge who returned the license had another hearing. So despite the immediately being in the statute twice, the trial judge and 2 other judges at least interpreted the statute that they could hold the hearing later.
As I heard the court discussing on Tuesday, sometimes having rules and statutes doesn't always guarantee conduct. All right, but here, the Commonwealth has no gripe or concern with Judge Kilmartin. Judge Kilmartin did immediately in the aftermath of the trial hold a hearing and make his decision. He filed the written findings a week after the trial. He then saw that the defendant, rather than following the Bauer proceeding and going to Superior Court for review, the defendant filed the notice of appeal and took an ordinary appeal to the appeals court and did not proceed with that, and the matter was dismissed under Rule 17. Before that happened, the judge allowed a hearing on a motion to reconsider. That was about 8 months after the trial.
So just, I know you're about to talk
Yes.
about this, but I just want you to make sure you focus on why, in the ordinary course, a judge can reconsider a motion and change his or her mind, but
Yes.
he or she can't do it in this particular case.
Well, I thought about how to say it, regarding Judge Kilmartin. Judge Kilmartin was faced with a request to reconsider, and he undertook to reconsider. And I was pointing out about the failure of the defendant to pursue his appeal, but that appeal was still live at the time that this reconsideration was done. I looked over the reconsideration cases that we have, and we encourage reconsideration, of course, to even in the notion just justice is advanced by making the decision as quickly as possible. But someone doesn't have the right to make a reconsideration of a case. A judge doesn't have the right to do that on a case that's already become final. The trial judge couldn't just say, I'm going to reconsider my ruling on a motion to suppress after this court had reviewed the case and made its determination.
Is this really a motion to reconsider? Because it's considering different evidence, right? I mean,
He's
is this
considering
really a
different
motion
evidence.
to reconsider? Because it's different evidence. The judge is considering the hardship, the fact that the person's, I guess, been sober for a certain number of years. It isn't like the judge is reconsidering the case. She's considering a different case, isn't she?
Well, in the case of the judge who we appealed from, Judge Guzman, she framed it or called it a reconsideration, or felt she could get through the immediate hearing language and that kind of restrictive language of the statute by terming what she was doing a reconsideration. She did consider new evidence, and this is something that the Commonwealth felt was not appropriate, because it was evidence that couldn't be available at the time of the original hearing, so it was outside the scope of what the legislature would think would be considered at that time. As I said, unlike the suspension for a conviction, where you have to go, say you got a 10-year suspension, which is what the defendant would have gotten if he had been convicted in this case. A 10-year suspension, he would have to wait 4 to 6 years before he could apply for the hardship license, and at that time, the statute says he has to show that he's brought his alcohol problem under control.
But
That's not the case
I'm
in this.
confused by one, and it's back to the chief's question, which is bothering me. So if he'd been convicted, he could apply for a hardship after how long?
If he'd been convicted of the 4th OUI, he could get a hardship license, one for work or education after 5 years of the 10 years, or 8 years if he had just hardship alone.
But then if he's acquitted, he can't, and he loses this motion, he can never get a hardship? Am I understanding the law correctly?
That is exactly what the law says.
Does that make sense? I mean, I understand the law may not make sense, but what's the rationale for, what would be the principle underlying that someone acquitted could never get a hardship, but someone convicted could?
Well, the underlying thing is this, as is reflected in some of our cases and is repeated in our brief, the legislature has found that driving under the influence and refusing to take breathalyzers repeatedly, as is the case here. This is not someone who has no prior record, who someone has, as Judge Kilmartin found in his ruling of denying relief after the acquittal. This person had 3 convictions.
I completely get that. He's a repeat offender. I just don't know why he's in worse shape on hardship for having been convicted than
Because-
acquitted. That's
Because
what,
the statistics were there that the legislature had before them, that the more times one violates this law, the more likely you are to be a menace
I know, but that
on the
doesn't, but
roads.
again, please address the one issue that's at least gnawing at me, which is that if he'd been convicted, he's a worse offender than if he's been acquitted, right?
If he had been convicted, well, the statute only counts convictions as far as adding up what the penalty is.
Right.
For how long the suspension is, whether it's a suspension for refusal or whether it's a suspension for the conviction. We look only at convictions. Now, I know that there are states which count refusals as convictions in that kind of a tally. This isn't one of those states.
Isn't it that this scheme and the legislative setup for drunk driving and licenses, is that they're targeting the refusal to take the breathalyzer so that it's more along of a civil penalty or something like that? It's not really within the scope of the criminal law necessarily?
Well, it's been determined in Commonwealth versus Luck that it's a civil matter. It's not necessarily punitive for double jeopardy purposes, and they made the determination that even if it were, it's a penalty that's imposed for the refusal, not for the driving conduct. And the scheme is that we have an informed consent law, which is the first part of this section F that this falls in, that explains that, and as this court has written, that it's important. The Supreme Court of the United States reviewed Massachusetts' statute in Mackey versus Matram and said that this is such an important tool in the public safety scheme of things that the legislature has chosen, that we can have this implied consent, informed consent. And before this man was asked to take the breathalyzer, he was told what would happen if he refused, and in writing.
And it's probably a fair conclusion that the legislature did not anticipate this situation.
Well, I'm not sure which situation. They did anticipate that someone would have 3 or 4 prior convictions
Right.
and therefore would face a lifetime suspension. They wrote that in the statute, so it's
Right.
hard to say they didn't anticipate that. What they may not have anticipated, and I suggest they certainly didn't sanction here, and this is what the crux is from the Commonwealth's point of view, is that a judge 7 years later, as we said in the Brock case, where the court came up with a solution that wasn't part of the statute, they said it's a sensible solution to a real problem, but it's not the way that our system works. You have to follow what the legislature asks the court to do,
Right.
and the court follows what those statutes say. Here, the judge took up upon herself, like in the Amaral case that I cited, seeing that this person had gone 7 years without doing anything that we would disapprove of, in fact, what we would encourage during this period of time, she took it upon herself to not allow the suspension to run its natural course, but to say, I forgive this. She paroled him, in effect, from this, and that's not something that she has the authority to do. That's not something this court has the authority to do, to grant parole to people. You cannot change someone's sentence, according to our rules, after a certain period of time, unless it's required by law.
I understand that. If we can go back to Justice Kafker's point, here's what, and I don't know that it's argued here. I don't know that there's a claim of that it's unconstitutional, it's lacking a rational basis.
There is no claim of that at all. And there's no claim that the Commonwealth waived its objection. Only the judge mentioned that.
But I do find perplexing situation in which we have John, who refuses the breathalyzer and is found not guilty, and then John gets a lifetime without parole with regard to his license. And then we have Bill, who also refuses the breathalyzer, but he's found guilty. And now he has the ability to get a hardship license after 5 years. Both refuse the breathalyzer. They differ only in that one of them was found guilty, and the person who refused the breathalyzer and was found guilty is able to get a hardship license, while the person who did the same thing but was found not guilty cannot.
I don't believe Your Honor's question, if it's meant to be based on the statute, is correct. That if one refused the breathalyzer before trial and then was convicted at that trial, there is no basis to end the suspension that's imposed for the refusal. And as we said in Commonwealth versus Luck, Both penalties are imposed by the statute. They are not duplicative. It's not double penalty. So the refusal will carry its own penalty, and if you do not win at trial, you do not have a basis to challenge it.
If you win the trial, you have an immediate right to get
You have
your
an
license
immediate
back, as opposed to someone who loses, and you also have a different burden of proof, as opposed to someone who loses. The presumption is that you get your license back unless the judge finds otherwise, if you win.
The presumption is that after the acquittal, your license will be returned unless the Commonwealth rebuts that by a fair preponderance to show that public safety will be
As
jeopardized.
opposed to someone who automatically loses their right to drive and then has to apply in.
Well, automatically, by fact of the statute and by fact that you had at the immediate time, in the first 15 days, you can take an appeal to the registry of your refusal. And after that is determined, you can take it within 30 days to the court, the trial court, and have it reviewed. So it's not like the refusal in the first instance is just because that officer saw it happen. It's reviewable at that time. This defendant didn't review it or didn't seek review of it at that time. He went to trial. He was found not guilty.
So just so I'm clear, you're saying with regard to my example that this fellow Bill, who both refused it and is found guilty, has essentially two parallel suspensions, a lifetime suspension for the refusal and then a 10-year suspension for the guilty.
Which is concurrent.
But there's so there are two separate things going on, and therefore you're saying he's in the same position as John with regard to the...
You can't improve your position on refusal.
By being found guilty.
By being found guilty or not. You know, if you're found not guilty, then there's going to be a review. But that's it. This is a strict law.
But I'm confused. If you're found guilty, are you completely prevented from getting a hardship exemption, or can you at some point get a hardship exemption?
If you're
found guilty...
If you took the breathalyzer, then there's no refusal suspension to interfere. What I'm saying is that the statute, the way it's worded here, that no license will be restored until the refusal suspension is complete.
No, I'm saying someone refused to take the breathalyzer. They're convicted of drunk driving. Can they ever get their fourth offense, whatever it is, can they get a hardship exemption? If they go into a sobriety program 8 years later, can they get a hardship?
I do not believe so on the language that's here, because it says that nothing will
Meaning
restore.
they can't go back to the registrar and get a hardship exemption. That's my question.
I understand, and I think I asked before, there's nothing here that indicates the registrar can do anything about this license if you don't go to the registrar immediately after the arrest and the refusal.
So it's a matter of putting aside whether it's good public policy or not good public policy, the intent here is not very complicated. It's to up the ante on repeat drunk drivers who decide not to take the breathalyzer because it's harder to prove the case beyond a reasonable doubt if they don't take it. Isn't the legislative intent clear?
The legislative intent is very clear on this. The legislature, though, as you know, Massachusetts, I put a paragraph in, Massachusetts is one of the very few places in this country that bans the fact of refusal from being used in evidence against the defendant at these trials. That, too, has an effect on whether or not the Commonwealth can meet its burden.
And that's my point about the legislative intent.
Yes. So their intent is to have the test taken. Take the breathalyzer test, because then there's more confidence, I would suppose, despite the debates about the breathalyzer machine. But even as a blood test, take the test, prove the evidence. Don't refuse. The penalty for refusal is very severe, especially if you have a habit of refusing like this defendant did.
All right.
Thank you.
Mr. Valancourt.
May it please the court, Stephen Valancourt on behalf of the defendant, Eric Richards.
Mr. Valancourt, could the judge have the hearing right away as required by the statute? The defendant moves right after the not guilty, and the judge take the matter under advisement for 7 years, see how the defendant does, and then decide whether or not, with a rebuttable presumption, that the license be returned, or whether or not the defendant can have the license returned?
Well, ironically, Justice Lowy, I had an instance in the Boston Municipal Court not long ago, where the judge had indicated that we have the right to an immediate hearing, but the statute did not require her to rule.
Right.
So I would suggest that could happen.
You could just hold it for 7 years and see how they do?
Yeah, and I think that the 7-year hypothetical that you posed is extreme, but it is a common practice within the district court for judges to hold these matters under advisement for a variety of reasons, and for no rhyme or reason with respect to the time limit that the court would rule on these motions. We think that the meaning of the word immediate as contained within the statute is designed to be for the benefit of the defendant, but it does not in any way limit his ability to present motions to the court at any time moving forward, as is consistent with the judiciary's right to reconsider motions of all sorts.
What about the issue of judge shopping?
Well, I sort of take offense to the notion of judge shopping. First and foremost, we assume that the judges at the district court and at all levels are persons.
You went in front of Kilmartin, you lost. Motion to reconsider in front of Kilmartin, you lost. Motion to reconsider the reconsideration in front of, I forget the other judge's name, second judge.
Correct.
And then you lose, because that judge says, well, Kilmartin ruled. And then 7 years later, another motion in front of third judge.
Well, I think that the threat of any sort of forum shopping is very much limited here, Your Honor, because first of all, if the trial judge were still available to hear the case, the law would require that justice to hear that motion. The defendant should not be penalized because the original trial judge is no longer available to hear the case. And the suggestion that forum shopping is a real concern, I think is very much limited, because again, it would have to be heard by the presiding judge in that court.
Well, could you wait 12 years? I mean, the judge is 58, not likely to return the license, and so wait 12 years and then see who comes into first session and file the motion. You've already had the immediate request and immediate hearing. Now it's 12 years later. The judge, that's how long it took for the judge to retire. You like the judge that's in first session that day? Can you have the motion to reconsider that day?
I think that if the legislature intended to put any restriction on the defendant's ability to seek relief under the statute, they would have said so.
So you could?
Yeah, absolutely, I would suggest that you could. I would also like to point out, particularly in this case, and I think it's important that the court not decide this case on some hypothetical defendant, but in this particular case, Mr. Richards walked in off the street and filed a pro se motion in front of the trial court that resulted in the restoration of this order. So to suggest that he, as a pro se litigant, had some knowledge of the trial court's liberal rulings, or however the court want to phrase it, or was actually sort of forum shopping or judge shopping, is simply not factually accurate in this case. And I don't think that this court should take those considerations into concerns into consideration when you're ruling on this case.
So under the statute, after a trial, the person found not guilty gets his or her license back unless the Commonwealth makes its motion. Isn't the implication that is to be at the time of the hearing, that the evaluation of whether restoration will likely endanger public safety is to be done at the time of the trial, as opposed to 4 years, 7 years, 10 years later?
Well, I would suggest the legislature has indicated that whether or not someone poses a threat to public safety is a fluid situation. And the fact that that may be the case in 2010 does not mean that that's the case in 2017. And as your honors have pointed out, this is the only recourse or avenue of relief for someone under that circumstance. In the legislature, I would suggest, recognizes that the judiciary is in the best position to decide whether or not.
Well, if that's the case, why do they have to put in immediately grant the hearing? If the goal is to be able to put this off for, as you said, you could do it for 12 years, why do you have to have the hearing be granted right away?
Well, again, we believe that is included within the statute to benefit the defendant who has just been acquitted of the charges against him. And so granting him an immediate hearing, it would seem just and proper under the circumstances, but in no way would that limit his ability to come back at some point in the future. I would suggest there be a number of instances where the defendant may not be in a position to request an immediate hearing in the aftermath of an acquittal for a variety of either personal, financial reasons.
So you don't have to file the motion immediately? Then?
No, he has the right to, but he's not necessarily obligated to.
So you could file the motion at any point in time, going to Justice Gaziano's point, depending on who's in the session. You don't have to.
Well, it wouldn't necessarily depend on who's in the session, Your Honor. If the trial judge were available, he would be obligated to hear the case, and if that was not the situation, then the presiding judge of the court would be obligated to hear the case. And we would certainly concede that it would be in everyone's best interest for the presiding judge to hear the motion, because he or she would be the individual most familiar with the facts. But it's inevitable.
7 years later, I mean, 7 years later, the judge is going to remember this particular drunk driving case?
Well, the issue isn't necessarily the facts of the underlying drunk driving case. The issue is whether or not the Commonwealth can overcome the statutory presumption in favor of restoration by demonstrating that restoration of the license would somehow endanger the community.
But isn't
this trial court?
What about the point made earlier that now the judge is looking at different facts, so they're not really reconsidering, they are considering this new set of facts?
I think that's absolutely correct, and that's the way it should be, and perhaps it should have been entitled a renewed motion for restoration of the license as opposed to a motion for reconsideration.
So that's okay. It's all right to, if you go by the statute and apply immediately after the acquittal, lose, 7 years later you can just reapply or
I would
remove?
suggest you can, Your Honor, because again, the notion of whether or not someone poses a threat to public safety is a fluid situation. And I don't know that someone who's been acquitted of a crime 10 years ago should forever be precluded from at least presenting a case to the court requesting relief. There's nothing preventing the court from denying the motion. It had been done on numerous occasions in this case. But in each and every instance, there was never a suggestion that the defendant was without right to bring the motion before the court.
What effect is the word immediate?
Again, we believe that the word immediate is to the benefit of the defendant in that it allows him to present that motion immediately upon the acquittal, but it doesn't in any way limit him.
So in this case, if he wants to do it the day of the trial, or he wants to do it in a week, but in what sense, since he already asked 3 times and was refused, doesn't immediate go out the window? You said to Justice Lowy, immediate could mean 12 years.
No, what I said was...
If I said to you, immediately, let's go get coffee, I don't think we was talking about let's get coffee 12 years from now, right?
Agreed, but I think that the point, Your Honor, is that any attempt to limit the defendant's right to that immediate hearing would be artificial and arbitrary.
But isn't your problem with the unfairness and the heavy-handedness of the statute the way it's written?
No, I don't believe so, because we feel that this is precisely consistent with the legislative intent. The legislature recognizes that, 1, there should be harsh penalties for multiple repeat offenders who refuse breathalyzers. 2, but when someone is acquitted of a crime, there has to be some avenue to seek relief.
Well, there is. There's other branches of government. There could be, the legislature could say, in 12 years or in 7 years, the person who refused the breathalyzer after 3 prior convictions can apply for a hardship license. The legislature can give that executive function to the executive branch.
I would absolutely agree with that, but in this instance, the legislature has given that authority to the judiciary, and that authority was properly exercised in this case. The Commonwealth is not challenging the trial court's factual findings with respect to whether or not...
I understand. I'm just responding to your point, it wouldn't be fair. To the extent that it wouldn't be fair, it can be addressed through the legislature. They made a choice.
They did make a choice. They made a choice to they made a determination that the judiciary was the appropriate branch of government to make this decision.
So just to be clear, immediately apply, you don't have to immediately apply, and immediately grant a hearing, the judge doesn't have to immediately grant a hearing, as long as it's the defendant who's not making the request.
To be clear, I'm suggesting that the defendant may request a hearing immediately.
Right, but
But his
doesn't have
failure
to.
to do so would not preclude him from doing so at any point in the
Right,
future.
but that's not going to help you because your client did apply for a hearing immediately. So it seems to me that what you're really saying is not so much that it's appropriate to reconsider an earlier finding because it's actually your finding based on new facts. You're really saying you have a right to reapply. You're saying you get to reapply over and over again before the court, which I guess here would be the district court in Ayer.
I would suggest, Your Honor, that because the statute does not pose any limitation on his right to apply, then yes, in fact, he does have the right to reapply.
But this is really a question of whether or not you have the right of reapplication, not whether or not this is properly a reconsideration of an earlier decision.
I would suggest, Your Honor, that's really a matter of semantics. The point from the defendant's perspective is that this is the only avenue of relief that he has. And to pose some sort of arbitrary limit on that based upon time constraints, I think would be inappropriate and unfair.
Can I get you to, I'm still not sure I know the answer. If he's been convicted, can he get a hardship exception from the registrar in these circumstances where he had three priors?
Your Honor, my understanding is that he would not be eligible because upon a conviction, there would be two concurrent suspensions running at one time, one for the conviction and then the lifetime conviction for the suspension, for the refusal.
Okay.
He would be eligible for a hardship under the suspension imposed for the conviction, but that would not do him any good because the lifetime suspension would still be in place. But I would suggest to the court that that would be appropriate for someone who was convicted of a fourth offense.
I was just
That's
more
not
worried
the instance
that, I
here.
was more worried that there was going to be a better treatment for someone convicted. I mean, convicted than acquitted, but that doesn't sound to be a problem. Oh.
It's not a problem in this case. I would point out that in the situation where someone under those circumstances refused a breathalyzer but was then convicted, the penalty for that fourth offense conviction would be lesser than the penalty for his refusal in this case because he would be eligible after that 5-year period.
Okay, thank you.
Thank you very much.